Okay, so hi everyone. Welcome to our talk today about alternatives to the H-1B. I'm Steve Maggi. Uh, just a quick intro. I'm originally from Argentina and I've been an immigration attorney for 22 years now. I had the pleasure of meeting Andries in Amsterdam November 11th, 2014. I'm wearing, Andries, the same tie I wore the day we met. This
There
is
you
my
go.
lucky Dutch tie that I'm wearing. Um, and then, so I always use it for these presentations for good luck. So I was lucky enough to meet Andries. I was able to get him an E-2 visa to launch his U.S. part of his business, and we've been colleagues ever since. He has provided 7 of my J-1 interns over the years who have been amazing. Um, and we wanted to talk today about the J-1 option and some other options because the H-1B lottery is over. So, Andres, if you want to say hello, and then we can dive in.
Yeah, good afternoon, everyone. My name Andries Bonner, CEO of Stage Global. Steve and I have known each other for a very long time. And Steve helped me out back in 2014 with my E-2 visa, and I'm a green card holder now, living in New York. CEO of Stage Global, we're a J1 program provider here in the States. We do that under different categories, and today I'm going to explain a few of those categories and how this could potentially work for your participants or for your companies. Yeah, Steve,
Yeah, I'll just
by all
say
means.
one thing. So, the H-1B visa, for those of you who are watching, probably familiar with it. Some of you may be employers that are looking for alternatives. Some of you may be foreign nationals who are either in the US on your F1 visa, maybe in what's called optional practical training phase, and maybe your H-1B lottery submission was not accepted. There are 85,000 spots for H-1B per year. 20,000 of those are for U.S. master's degree holders, and then there are usually more than 500,000 registrations for H-1B. So if you can do the math, 80% or more of those who try to get H-1B selections are not chosen. I had a consultation this morning with a guy who has a PhD who missed out 4 years in a row, and now we're working on his O-1 visa. So that's why we're doing this, because we want to help not only foreign nationals be able to stay, but we want to help employers bridge the gap between usually an F1 or OPT status to another visa that allows them to work and keep those working relationships intact. So that's what we're going to talk about today. So, Andres, if you'd like to jump into the J1, and then I'll pick up after you're done.
Absolutely. Thank you, Steve. By the way, for everyone, there's a Q&A button at the bottom of your screen. So if you have any questions, feel free to file those questions there, and Steve and I will be addressing them after the presentation. All right. So the J1 program. The J1 program has quite a few categories, I believe over 14 or 15. We at Stage Global, we work with 5 of them, and one in particular is the J1 Research Scholar visa that we see is used by many people who also consider H-1B or sometimes other visa. Um, the J1 Research Scholar is an exchange program visa that allows participants to stay in the US and work in the US for up to 5 years. It's a relatively easy visa to obtain. Typically, our processing times are anywhere between 4 to 8 weeks. And with 4 to 8 weeks, I mean from the start where we gather all the information for the visa, go through the processing, and have you go through either consular processing or a change of status to USCIS. So if we compare that with other visa categories, this is typically a pretty fast track that allows you to get started pretty soon. I'll dive into the details in a little bit. With this visa, we see quite often students, F1 students, who've used their OPT and secured a position in the US with a research component, that this is a potential good visa for them. Therefore, we also see when OPT is up that participants change to this status quite often. The visa does allow you to also explore other visa options that Steve will go into in a little bit as well. Who can apply for this visa? The J-1 research scholar, I just mentioned it briefly already. The main thing what we typically look for is that the position that's being offered has a research component to it. And that research component can be interpreted quite broadly. So I listed a few examples here on the screen: technology, market research, market analytics, business research, academic research or universities, for instance, research centers. Medical research is something that's quite common as well. Product development, R&D. We definitely see the research scholar being used by AI related positions, so the technology, IT engineers, those type of positions can potentially all qualify for this. There is, when it comes to the description of what qualifies, it's really that research component that we need to highlight there. So whenever we start the process for this visa category, we always work with a template offer letter, and that offer letter, that's a template that we provide, and that offer letter should explain the research component within the position. I'll dive into the process for that in a little bit as well. But the fields, like we see these fields often, doesn't mean it's limited to this only. So if you think this might be an option for you, you can always double check. We can let you know if your field is basically if the position qualifies. The J-1 research scholar, up until a couple of years ago, was mainly used by research institutions as well as universities. Under the Biden administration, this was broadened up a bit to be used by private entities as well. So we see quite some tech startup using this category, private companies in general, also nonprofits. That means like universities and research centers can still use it, obviously. But under the Biden administration, that was broadened up a bit. Startups, in some occasions, can work as well. We do require there to be at least one full-time employee or somebody on the payroll. So it cannot be a founder who just starts the company, basically, and without any employees there. A brief overview of how this works and how the process works, basically. If you have a position secured, so whether your company, you have like somebody you want to hire, or if you're looking for a company, so you're an F1 or OPT, for instance, and you have a position secured, the first thing is what we do is we always start with a pre-intake meeting to just go over the position and over the qualifications. We send you a template offer letter and request for you to draft this and submit that. And we do a first check on eligibility. Based on that letter, we may say like, hey, some adjustments are suggested, or we can start up based on that. The main thing we look for when it comes to the background of the participant is either educational or work experience background in the field that you're going to be working in. Once we process the application, that can take a couple of weeks, and approve it, a DS 2019 form is issued. And with this form, you can either, if you're outside the United States, apply through consular processing, so you have an appointment at the embassy or consulate, or file a change of status to USCIS. That change of status is something that we recommend using, for instance, Steve, for some support when it comes to filing the petition well. If through USCIS, the processing time can vary a little bit. Applications through consular processing is typically a week or two. The cost of this visa, I just briefly lined it up. We can definitely share some fact sheets about this as well. The first year of the J-1 visa is $2,500. In addition, for each additional year, $750. And the total duration, maximum duration of this visa is 5 years. There's a one-time CVIS fee to be paid for. It's $220. An obligatory health insurance is $79 per month, unless the company offers health insurance. And the last thing to keep in mind, if you wish to go through an expedited processing, and there's $1,000 extra for that, then the processing time is typically within 5 working days. We have fact sheets where we can share all the information regarding this as well. Besides the J-1 Research Scholar, we do have a few other visa options. One is the J-1 Specialist Visa. Very similar to the Research Scholar, as in like documentation-wise, what we need, just an offer letter, basically. The only difference is that there's no research component required there. So you're coming over to the States as a specialist in your field, education and or profession. The maximum duration of this visa is 1 year, so it's significantly shorter. It can be used as well for something like transferring into an O-1 visa, for instance, but I think Steve will be able to give you some more information about that later. Some alternative programs we run are the J-1 intern and J-1 trainee programs. I just want to touch base on that briefly. This is for people who are outside the United States with a degree or work experience outside the US and gain a training either through internship or traineeship in the US up to 18 months. Doesn't require any type of research component. So it's a shorter type of visa that you can apply for, mainly for people who want to come over to the States for a temporary training. That is in a nutshell what I have here. This contact information we'll be sharing later on as well. And I'll be taking some questions and answers in a little bit too, but I'll hand it over to you, Steve.
Thanks, Andries. And please, I want to encourage everyone to put their questions in now. If you have any J-1 related questions, put those in there, please. So we can answer those at the end of the session. What's most important here is that you keep your questions limited, meaning not so specific to your own situation that we can't, help use the answer to give or shed light for other people to learn as well. So we want you to, if you have questions that are really, specific, you can contact us after, and we'll share our contact information as well as the recording of this after. So let me share my screen. Can you see my screen? Andres, can you see?
Yes, I can see it, Steve.
Okay, so there are various visas that people can apply for, but I think it's important for one to understand first that you must be applying if it's a change of status within a specific time period, depending on what status you're in, and we can talk about that more. I'm going to limit my talk today to 2 kinds of visas. I mentioned my client this morning that had 4 misses at the lottery 4 years in a row, who happens to be, luckily for him, in something called curricular practical training, which ends next year. So what we're doing is methodically we're going to build a case for him. And it's very important for people to understand that this is not something you have to qualify for in every category, but actually 3 or more, and that's why it says here, need 3. So I'm going to talk about a little bit about each one of the criteria that is used to decide if someone is really what's called extraordinary or not. This is called the Extraordinary Ability Visa, for those of you who have not seen this before. The first one is awards or prizes. The second is membership in distinguished organizations, media coverage, and that is about the person in their field of work. The fourth is authorship of scholarly articles. The next one is called original contributions of major significance in the field. The sixth is high salary or remuneration, or what's called compensation. The seventh is judging the work of others. And then 8 is critical role in distinguished organizations. And this is extremely useful for people who have work experience and they're not just going straight from being a student. Let's talk about awards. This one is the EY Entrepreneur of the Year is one. It's very important for me to be clear about this, is that there are no limitations in terms of profession for O-1, and unlike an H-1B, there are no educational requirements. We have gotten many O-1s in the past few years for founders, and for what we call AI engineers, which are in the field of computer science, who have never gone to college. It's not a requirement to have a certain degree level or a certain kind of degree like an H-1B, and that's what makes O-1B much more flexible. We have a lot of clients who are leaving their course of study. They're halfway through, let's say, at Stanford, and they qualify for O-1, and they're starting to run their own companies or work for other companies like a Tesla or an Amazon. So category 1 awards is anything that is national or international. It has to be an individual award, not a group award. So you can't say I worked for Google and we won an award. It has to be individual, and it cannot be something that's academic based, meaning it cannot be something that you won while in school, unless it is open to non-students, and these are the nuances that are important. But fellowships are the #1 way to qualify. So if you've won something like a Thiel Fellowship, then it's very possible. Now it's important for me to also say one of the tips for this is that if you receive funding, let's say you start a company and receive funding, you will be disqualified as having won an award, because if there's an exchange of funds or there's an investment component, then it's not an objectively won award. So this is why you need to work with and craft your case with someone who does this every day, because it's highly nuanced what qualifies and what does not. Membership in distinguished organizations, you must show that the membership is selected. This is not pay to play. The organizations must also provide a confirmation letter that discusses the criteria used to select members and mention specific people who comprise part of the selection committee to show that they are established experts. This has to be within your field, and I think I didn't mention it up front, but the first thing that we do when we submit when we're crafting a case is we define the field. We make it as broad as possible so we can bring in as much evidence that qualifies as we can. So if you are an engineer, and I had this case, I had an engineer who I got a visa to be a DJ. We couldn't use his engineering awards for a visa that allowed him to be a DJ. So his field was music. So if you're multi-talented, we have to define what the most accessible field is for your case, and it should be the same field that you will be working in. Media is king, as they say, and they used to say that when I was a journalist before I was a lawyer. Media to me is the strongest category. It's what I call a 1+. Why? Because it qualifies you when it's about you in your field, and it's in either what's called major media or major trade. If you're a tech person, it's in a tech publication, for example. But it also gives the possibility of legitimizing other categories and other criteria by mentioning your fellowship, your judging of the work of others, any other accomplishments that you've had. It legitimizes those. It's a way to certify the legitimacy of all your accomplishments. And so Media is wonderful. If you can get it organically, that's the best way. But what matters most is the strength of the source, and that goes for a lot of these different criteria. But media is the best way to put it, as they say, the cherry on top of your case. USCIS loves academics, people with an academic foundation. So if you are somebody with a PhD, or you're a scholar, like Andres works with J-1 scholars, there's research. If you're a research person and you have published scholarly articles, this is an almost irrefutable proof for this specific criterion. And so I always encourage people, if they can get published, to do so, because this is, I wouldn't say it's more strongly weighted, but they will take your petition much more seriously. Now, of course, if you have a totally different profile, that's okay too. What you have to try to do is build the strongest case you can based on the evidence that you can actually acquire or generate. And if you're not a writer and you don't do research, this does not apply to you. But if you are, it's really it's one of the best categories. This one is, and people are very emotionally attached to this category. Everybody wants to believe that they have changed the world somehow, but that is actually the standard that is required to be proved if you want to show that you have an original contribution of major significance. What does that mean? Number one, the contribution has to be yours. It has to be attributable to you, and it has to be significant in the field. This is what I call game changing. So if you've created a code that was used for a platform that is implemented and then used by 1 million end users, and that is attributable to you, then you can use this. But the majority of cases do not qualify here. What they want to see ideally is patents in your name that are registered and being implemented. So you have to be very careful here in how you use this, because what you cannot do, my philosophy is to not throw things at the wall and see if they will stick. A lot of attorneys do that. They try to qualify you with every bit of proof they can think of. My philosophy is quality over quantity and quantity of quality. So if you have 3 publications, then that's better than 2. If you have 10 peer judging, instead of 2, that's better, but they have to be of the highest quality. And what your attorney should do when they're helping you mold your profile for O-1 is to help you vet every single proof that you will include in your case, because you're only as strong as your weakest link. And if you throw in a random award or try to argue something that won't meet the test, it will make your case weaker overall, and that's what you don't want. So it's better to build a lean case than to just throw as much documentation in as you can. The high salary remuneration criterion is interesting because it mentions remuneration. What that means is that it's not restricted only to salary. So you can take total compensation and compare it to salaries, and what they want to see is that you're in the top 10% for your specific position. So this can be a position you had 10 years ago or 5 years ago, and the great news is it can be also places you've worked overseas. So let's say you're from India and you were an engineer, but you were working for a US company. You're getting a US equivalent salary in India, but that puts you in the top 10% for engineers in India. We can use it. They will look at total compensation, and then they will look at the salaries that people make. And that's how they love to look at the Department of Labor Statistics. It's called Bureau of Labor Statistics for US comparison purposes. But if you have an overseas job that was well compensated, then you can use that as well. The tricky part is equity. People love to talk about the equity they have. Like the person I spoke to today said they had equity in Tesla because they worked there. But if it's not liquefied, if you haven't been compensated, if you haven't cashed that out, it's a hypothetical value. And so it has a lot less weight. So it's not to say that we can't mention it in your petition, but you cannot say, I will make this one day and therefore I qualify. Um, this is my favorite category probably because I think it is the easiest to add. Now it depends on what your profession is, but there are many symposiums, conferences, hackathons that are out there in your fields that you could be a judge at and you can volunteer to do this. But they need to be elite. Cal Hacks, Berkeley AI Hackathon, Hack Harvard, Hack MIT, Stanford Tree Hacks. Those are the five elite ones, right? It can't be Bumbleberg University, and it can't be a private equity judging that you're doing for venture capital. It needs to be elite. The absolutely irrefutable way to do this, though, is the traditional peer review. So let's say you went to Stanford, you got your degree there, you contact the Stanford Tech Journal, and you say, I want to volunteer my time to review submissions for publication in your journal. Or you do that for something like an IEEE conference. Very few people want to take the time free of charge to do this, but it is an irrefutable proof of the recognition you have to satisfy this criterion of judging the work of others. And this is what I call the low-hanging fruit, especially if you have any sort of academic background, you should be able to judge the work of others. The last category is for people with work experience, and there's two prongs here to this requirement. It's called critical or essential role in an organization of distinguished reputation. What does that mean? That means first you have to show that you're critical or you were critical in your position, and that is achieved through a letter that is written usually by the law firm with the help of the client, but signed by someone at the company that gives detailed information and explains why the person was or is critical to the overall success of the company. Where it gets tricky is proving distinguished reputation. Oftentimes someone, if they work for Tesla, I'm giving the example from this morning of the client that we have, it's easy to prove that Tesla is distinguished. You can show the revenue, you can show the number of employees, all the media about it. But it's hard to prove that someone who works at a company with 10,000 or more employees is critical to the success. So that's where if you have a role in a smaller company, it's easier to prove critical role. Might be more challenging to prove distinguished reputation. This is all a balancing. So you have to take the strengths of each candidate, build on those, and try to generate strong proofs in the categories that really apply. And depending on how much time you have left in your status, or if you're outside the US, you should take as much time as you need to build these profiles with someone who knows how to do it, because the success rate for O1s is quite high if they're presented correctly. And so the O1 is wonderful because, like I said, it's agnostic in terms of vertical, profession. There's no degree requirement. There's no cap like H-1B. You can be outside the US or inside the US. You can be from the smallest country or the biggest country. You can still qualify, but you have to obviously be good at what you're doing, but you also have to build the profile well. So that is O1 in a nutshell. And I'm going to just speak a little bit about one of my other favorites. I've done probably about 500 O1s and probably about 500 E2s, including my good friend Andres a long time ago. I'm going to talk a little bit about E2. Now, the reason why I spent more time on O1 is because there is no nationality restriction with O1. E2, on the other hand, is accessible for people from treaty countries only. Okay, so here's a few caveats. Number one, if you have 3 or 4 different nationalities and passports, you can use the one, believe it or not, that gives you access. So let's say you're Brazilian, which Brazil does not have a treaty, but you have a UK passport, you can apply through the UK passport. If you're Brazilian and your spouse has a Spanish passport, you can apply, they can be the principal applicant. So there are workarounds, but if you're from India, Indonesia, Russia, South Africa, any of the BRICS countries, then you do not have access to this. And I'm sorry, I apologize in advance for those that may not have access. If you get if second passport, it might be an option, but I just wanted to talk about this because it's very underlooked and underserved. There are no caps on this. It's processed year round, and it's processed usually directly through the U.S. embassies and consulates, like the one for Andries, which was in the Museumplein in Amsterdam, through that consulate. If you have a passport, and you can check the current list, I believe there are 81 countries on there, including the Netherlands. You can check the E-2 list. It's the Department of State, and it will show you which countries have a treaty, and then you can check how long the duration of those visas is, the maximum. It depends on which country you're from. So this is a business-based visa, so this is more for entrepreneurial people. We use a franchise model for a lot of these. So for alternatives to H-1B, this could be, okay, I didn't get an H-1B, but what I really want to do is run my own business. Well, if you're from one of those countries, you can do a change of status, and then, or you can process outside the US. But there are certain things that you have to do. Number one, you have to calculate how much needs to be invested in order to cover 1 year of operating costs. So you have to have an investment. This is an investor visa, okay? The investment funds do not need to be provided by you, but they have to be legally sourced, which means we have to prove source of the funds. So if you have, we had an Italian client who got sponsored essentially by Google, not to work for Google, but they invested in his company. He didn't put up one penny of it. But because he was Italian and he was the majority owner, he was able to access this. So another requirement is you need to have 50% ownership from that country. You can't be a 5% owner from Spain and 95% of the ownership is in the US. This is how you not only get the status, but you keep the status. And so that's very important. The funds have to be invested in the US company that you set up. They have to be more than what you project for costs. You have to have a business plan that shows you will create jobs. That is why the visa exists. And then you have to start putting the money into motion before you submit. So this is a leap of faith. You have to take a chance. What's really important here is that you make sure you are completing and qualifying in all the categories, legal categories, making the investment, which shows a real interest and dedication to that specific investment. And then you can get, depending on what country you're from, potentially up to a 5-year visa. So that's the E-2, and you can get it from the US or outside. But it's a wonderful alternative to H-1B if you can secure investment and you want to be an entrepreneur. That's all for now, Andries. Should we dive into questions?
Fantastic. Yes. Yeah, let's do that. We do have a couple of questions already that were filed, and I just answered one as well that was in regards to J-1. But just to answer that for everyone, the question was, how long does a J-1 visa process normally take, start to end? Typically 6 to 8 weeks. So starting with intake, and then the end, meaning you have your visa in hand after your appointment at the embassy or change of status. Expedited processing possible within 4 weeks. So it's a relatively fast.
We should probably add, Andries, to that is that there are also fees, USCIS fees.
If you do change of status, there is indeed a USCIS filing fee. If you do a consulate processing, there's a fee at the US Embassy, $185.
Yeah, that's the cheaper route for sure. But if you want continuity and sometimes staying with the same employer, even, it's better to do it within the US.
Pablo was asking, can I apply for my O-1 while I'm under the J-1 program? Steve, maybe something for you to answer there.
Yeah, I think it's important here, and this is something that we see, and when I work with Andries, we're always making sure we check this, is does your J-1 have a restriction, right? What we try to make sure of, and when we're doing the J1 Scholar, we haven't seen this, but there are people who have some sort of government, their country's government is involved somehow in the program, and they get what's called a 2-year home residency requirement. So if you have a J1 with that requirement, you have to get a waiver, or you have to be outside the US for 2 years, right? Not consecutively, but accumulatively. So that makes it hard to, or almost impossible to change status. So you have to make sure, if you're working with Andres, this will not happen. But I've seen other cases where this happens, and then you can't change to any. Well, I'm sorry, you can change to O1, but you cannot change to other statuses, and
No.
it's really confusing as to what is allowed
It,
and
it,
what is
de-
not.
it depends what J1 you're under. That's correct. And typically, if it's a government-funded program, then there might be that 2-year rule. Um,
So yeah,
all of our programs, typically the intern trainee and the specialist and research scholars, do not have that 2-year home residency rule.
yeah, and that's important. So the answer, going back to the question, is yes, it is possible. But what is not possible, ironically, since this is alternatives to H1, is you can't go to H1 when you have the 2-year restriction, but you can go to O1, which is
Yeah,
confusing.
immigrant and non-immigrant visa.
Yeah, well, yeah, they different intents, and it gets very nuanced. But as long as you don't have the restriction, yes, you can. O1 is a great way to go, and vice versa. I mean, this J1 Scholar really is game changing.
All
Let's
right.
see what else we've got. Okay, when I arrived in New York, I was not in the country of my citizenship. My employer could not apply for J1 but H-1B. Is it the only reason? Can a J-1 be applied for after the end of H-1B validity? Okay, so I think what they're asking is, can they transition from H1 to J1?
It's a good question. I'm not 100% sure if we can do change of status there.
Yeah, I have not seen that one. That is a good question. Generally, people who are on H-1B, by the second 3-year period, they're going through a labor certification process. And if the employer is not willing to sponsor, we do a lot of H1s to O1s. Sometimes employers just don't want to take that expense or that risk of sponsoring someone for a green card and that person leaving their employment. Um, that would be something that we should definitely look into. I have not seen that jump from H1 to J1. It's mostly from the F1 OPT straight to J1 that we see it.
Was a follow-up question from Julian as well. Is a French or foreign doctorate as valued as an American PhD in the visa application process? I think that's a question for you.
Okay, so it's a nuanced response because it depends on the category of visa you're applying for, right? So if you're applying for O1, there is no degree requirement at all, like I mentioned. The same for E2. If you apply for E2, and I think the French get 25 months for each E2. It's just depends on the investment and the business proposition. The O1 depends on how many criteria you fulfill, but there is no educational requirement. When it comes to H-1B, what you have to prove is that the position generally requires a bachelor's or more in a specific field or similar field, and you need to have the job offer. But if you're above a bachelor's and the job requires just a bachelor's, then it doesn't matter if you have a PhD or you have or a foreign doctorate. But you're going to need what's called an equivalency evaluation for your degree, and you're going to want to get that done. But that's for H-1B only. The rest of these do not require a specific degree.
When it comes to J1 research scholar, there isn't really an educational requirement either. So we take a look at the full pictures of your experience through work or other certification backgrounds. So there are different routes we can take there. Same goes for the J1 specialist.
Okay.
Uh,
Go ahead.
Go ahead.
Oh, I see one about if I can't get a full-time company sponsor, can I still apply for O-1? So the answer is yes. The O-1 allows for a variety of different sponsors, which makes it incredibly flexible, and it's great for people who want to run their own companies or be independent contractors. So there are three arrangements you can make. One is petitioner sponsor, which doesn't apply here, right? Because you can't get a full-time job. The second is a visa petition agent, which is a US citizen or green card holder who will authorize you to work essentially through your relationship, which is built on a very simple contract. And then you do what are called deal memos, which are project-based work that fill up an itinerary of time. So you can have 2 or 3 to start, and then as time progresses, you can take on new projects or new part-time work as long as the visa petition agent signs off on those. That's the most flexible agreement. And then the last one is you can also co-found a company as long as there are other decision makers in your company that can have what's called signatory rights and voting rights to who is hired, who is fired. So you're not self-sponsoring directly. You could also have a company you co-found sponsor your O-1 that way. So you don't necessarily need to find an outside sponsor. There's so much flexibility with O-1. What matters most is that you qualify under 3 or more criteria like we talked about, because otherwise it doesn't matter who your sponsor is. But there is incredible flexibility in terms of sponsorship, and then that allows you to work in many instances in a very independent way.
So the O1 has a lot more flexibility when it comes to employer, host company, basically. When it comes to the J1 research scholar, your visa is connected to your host company as well. So if you were to leave the company, you'll have some time to find a new company. But if you don't, your status will run out basically. So you'll have to leave the country. So the position, the company is connected to your visa right away, directly.
And I think it's important for people to understand, Andres, and we see this a lot, the concept of a grace period, right? For an F1 OPT, you have 60 days once your I-20 expires to jump to another visa status. So if you can line up an O-1 or line up a J-1 or something else and do a change of status, as long as you apply within the 60 days, even if it takes a month, let's say with premium processing, to get an approval, or even more if there's a request for evidence, you are maintaining legal status if you apply within the 60-day window.
It's good to know that that doesn't mean applying with us. That means applying with USCIS. So
Correct.
it has to
Absolutely.
be on file there. So don't contact us on day 59 with your case. That might be a bit on the late.
Yeah, if you need 4 weeks to get things ready to submit or more with Andres' team, then you're going to make sure that's well within or before the 60-day window begins.
Okay.
We have a few more questions, looks like.
Yes. This one is for you, Steve. Can I do a change of status from within the US to E2? What happens if I want or have to leave the US after an approval?
Okay, so number one, like we said, you have to apply within the period that you're allotted. Let's say you're in the US on a B1, B2 visa, 6 months. You have to submit, there is no grace period. Each visa has a different grace period, right? So you're in the visa status. You apply to change status within the US. That is not a visa application. People confound this all the time. It is nothing more than a visa status change, which means you are then given the status that applies to the E2 visa. But you don't get a visa. People think, I do a change of status. If it's timely filed, you can get an approval with premium processing, and then you're automatically in that status. You can run your E2 company right away. But that does not mean that when you want to leave, you just make an appointment at the embassy and they give you an E2 visa because it was approved in the US. It's not like an L1 or an O1 or almost any other visa, because the E2 requires that you submit a full application at the corresponding US embassy or consulate. So if you're from, let's say, Turkey, Then you have to go to Ankara and interview for a visa, but you have to have submitted the case 2 months in advance and gotten an appointment, and they have to approve your visa. They have to look at the merits of the case again and approve it. So you have to be very careful. You're planning your international travel, and you have to understand that you are taking a risk that you may be denied the visa, even though you were approved by USCIS in the US. We have a client that is in the US. If they want to go back to Colombia, which can take a year to process, an E-2, believe it or not, they're taking a massive risk that they won't be, because you can't just come back in with a visa stamp. You have to go through the formal process. And so that's the downside. We did a lot of these during the pandemic, and people are still here because there is no guarantee that you will get approved at the US Embassy. And so that's one of those thorny things. Most cases, like a J-1 or an O-1 or other visas, you will just get a stamp.
Exactly. Yeah, I was going to say when it comes to the J1s, what we see, it's a very quick process typically where you make your appointment, takes you a week or two. We do mention to people, if you make that first travel abroad when you did a change of status, make sure to have flexible travel plans. Sometimes we have clients who say, okay, I have to be outside for a couple of days for a conference. You may want to reconsider that or have more flexibility when it comes to traveling abroad to get that updated visa stamp there. But I can see how that differs per category. Obviously, Steve knows that way better when it comes to the non-J1s. With
And
the
that's what,
J1s, we typically see that it goes pretty quick.
yeah, and Andres has seen my presentations we presented together. The first thing I always say is do not improvise.
Right.
Don't improvise anything. Don't say, oh, I can go to see this incredible music festival in France. I'm going to go. And then all of a sudden you can't come back because you didn't apply for the E-2 at the embassy before.
Yep.
Things like that I've seen every single permutation over the years. Do not improvise anything. Make sure you're well informed whenever you decide to take your next immigration step. Looks like we
All right.
have a question from Rodrigo.
Yes.
Okay, this is a pretty general question. Employer sponsors, what are the requirements? Money amount or general guarantee? Okay, a couple of different things. Most visas require an employer sponsor. I talked about O-1 as having the flexibility for a petition agent that's an intermediary that allows you to work as an independent contractor. There are almost no situations like that with other visas. It's almost always going to be an employer sponsor, which is either a for-profit company or a non-profit or a research institution, but it's going to be an entity that sponsors. When it comes to salaries, H-1B is the most restrictive because you have to do what's called the labor conditions application, and the Department of Labor will tell you what is the minimum amount that this person has to be paid, and you have to pay that amount. But that is not the case for O1, L1, E2. What you want to do is present a reasonable salary. What does that mean? It has to be a living wage. If your company's in San Francisco, you can't put a salary of $36,000 a year because nobody can live on that. So you have to figure out what is reasonable. It's the H-1B that's the most restrictive. The rest are much more open. For E-2, for the first year, if you are the investor, you're not required to pay yourself a salary. But otherwise, the expectation is something reasonable. And then guarantees. It talks about guarantees. So if you have an employer sponsor, you are beholden to that employer sponsor. If the company closes or you no longer get paid, you can lose your status. And that's important for you to understand. You can't get a visa and then the company doesn't pay you. Even though it's not going to be reported to the immigration authorities, that means that you technically are out of status. And the other thing that's important, unless it's your own company, like on an E2 or an O1, you can be fired at any time. So what these offers of employment that are involved in these cases will say, we intend to employ this person for 2, 3, 4, 5 years, depending on the maximum duration of the visa, right? But it's still at will, which means if tomorrow they don't want to employ you anymore, they will notify you, and then you have a small grace period depending on the visa to find another sponsor or change your status. So the guarantee is not there. They are responsible for you. So that's why a lot of my clients like the E-2 and the O-1, where they found their own companies, because then they are in control of their own destiny. Otherwise there could be a layoff or any number of things can happen, but there are no guarantees.
So when it comes to the J-1, that works a little different. You, as a company, do not have to sponsor. Instead, we take care of that as a third-party sponsor. Makes the process quite a bit easier, and also documents that are needed from you as a company are limited. When it comes to J-1 research visa, there are no requirements when it comes to income. We also have positions that are unpaid. We also have positions that pay over $200,000 or $300,000 a year. So it's everything in between, basically. Yeah. So those are typically the AI researchers in Silicon Valley,
Yeah,
but
if I had a child, I would make them an AI
oh
engineer.
yeah, it's unbelievable. So there are no requirements when it comes to that. And sponsorship is arranged through us, so not by the company. That makes the process a bit quicker.
Yeah, and I would do a quick plug for Andres. His firm is his company is different than all the other J1s that I know, organizations, because they also do some matchmaking. They also help pair really good candidates with potential sponsors, and that includes my firm. We did, like I said, 7 J1s over the years,
Right.
and that's
Yeah.
very, very unique.
Under the J1 intern and trainee category, we provide placement service. So we have hundreds of people per year that apply and that we have available in all sorts of fields. So if you're ever looking for a J1 in any type of field, shoot me a message and our placement team can help out with that as well.
Yeah. Looks like we have one last one. What
Yeah.
is the difference between O1A and O1B? So since we have 5 minutes, I'll keep this short. There are 2 designations for the Extraordinary Ability Visa, and they are divided between creative fields or artistic fields and non-creative, non-artistic. So the majority of the people who are victims of the H-1B lottery are going to fall into the O1A category. I'm happy this question was asked because my presentation, my brief overview was O1A. O1B is for creatives, and sometimes people are on the line. They're like content creators, for example, or they're creative directors. They may not be a singer or a dancer or a cartoonist or something. It might be something that's on that line between O1A and O1B. And that's where a good attorney will be creative and pick the right path, what I call the path of least resistance. O1B, for example, includes expert letters as one of the criteria. It's called recognition, significant recognition, which O1A does not. So what you do is, if you're evaluating and the person is arguably a creative, see which of the 2 paths it has the least resistance, and where you can really embellish and fortify and put emphasis on the categories and the criteria. There are only 1 really, or 2. There's media and critical role that overlap. The rest are different. So that's the difference. There are 2 good paths, but it depends on your specific situation, your vertical, your profession, what you do, and that's why O1 is so fantastic, because you can mold it to the person, and then once you pick the path, build the profile for them to qualify. I think that's all our questions.
I think so.
So for all of you out there's hope. There's lots of alternatives. If you're an employer, it's good to look at your hiring plan and see a year out, who do you have, who do you want to keep, do you want to depend only on the H-1B? I call H-1B Plan C. There are always alternatives that you should put into motion if you really want to retain people. And then for those people who are outside the US, the O1 does not discriminate by nationality. There's no cap so you can build your case over time.
When it comes to J1, we can always have a brief intake call to talk about the situation, and we can do a first check on eligibility. No fees involved there, so you get a better idea of your options there. So thank you everyone for your attention and your interest here, and we
Yes.
are available for any questions.
Thanks, everyone. Pleasure.
Have a good one.
Have a great day.
Bye bye.